Welcome back to our channel, Exposing the Great Australian Government. In today's video, Criminal Code Act 1899, we will show you the facts on where these purported politicians and political parties removed treason from the Crimes Act. This to me is an admission of guilt. Why else would they remove treason from the Criminal Code? Trying to save their own skins and necks? Dick has been like Hansel and Gretel, following the breadcrumbs, which has led him to uncover some of the treason that these criminals and traitors have committed and are still committing. We know that there is plenty more to be uncovered, but what we have at the moment is enough evidence against these criminals and traitors to have them all charged with treason. This won't happen without the people. Unity is the key, and sticking to only factual information that can be backed up with evidence. And this is what Dick has given us, all the facts and evidence without us having to spend half a lifetime researching this information. We understand that this information is very hard to comprehend, so please don't hold back your questions. All we are trying to do is help educate and show every Australian what these purported politicians and political parties have done behind all our backs, using their official government paperwork. Another good quote: "Those who are too smart to engage in politics are punished by being governed by those who are dumber." Plato. Unfortunately, this is something we all need to do. Or are you happy being ruled over by these pedophiles? Let's get into it.
They also admitted treason out of their so-called acts and legislation. Why would they do that?
I've heard of that before.
Why would they do it?
You know why they would.
This is a research paper put together by Dick Yardley. Criminal Law Amendment Act 1997, Queensland, Act number 3 of 1997. Where they omitted treason from the Criminal Code Act of 1899, Queensland. The Criminal Law Amendment Act 1997, Queensland, Act number 3 of 1997, by Section 120, Schedule 1, provisions of Criminal Code repealed, omitted from the Criminal Code Act 1899, Queensland. In Part 2, Offences Against Public Order, Chapter 6, Treason and Other Offences Against the Sovereign's Person and Authority, Section 37, Treason, Section 38, Concealment of Treason, Section 39, Treasonable Crimes, Section 40, Time for proceeding in cases of treason or concealment of treason, 2 witnesses necessary. Section 41, Inciting to Mutiny. Section 42, Assisting Escape of Prisoners of War. Section 43, Overt Act. In Part 8, Procedure, Chapter 63, Evidence, Presumptions of Fact. Section 633, Evidence on Charge of Treason. In Part 8, Procedure, Chapter 71, Miscellaneous Provisions, Section 696, Names of jury to be given to person charged with treason or concealment of treason. These omissions from the Criminal Code Act 1899, Queensland, effectively removed the authority and the protection of the Crown from the citizens of a state of the Commonwealth, known as Queensland. Queensland Criminal Code Act 1899, reprinted as in force on the 5th of September 2009, reprint number 7B. End notes 10. List of annotations for Criminal Code, Part 2, Offences Against Public Order, Chapter 6, Treason and Other Offences Against the Sovereign's Person and Authority. Chapter heading omitted, 1997, Number 3, Section 120, Schedule 1, Treason. Section 37, amend 1922 13 GO5 number 2 section 3 part 4. 1998 or amend 1998 number 88 section 5 schedule 2. Amend 1992 number 48 section 207 schedule. Omit 1997 number 3 section 120 schedule 1. Concealment of treason section 38 amend 1998 number 88 section 5 schedule 2. Omit 1997 number 3 section 120 schedule 1. Treasonable crimes section 39 amend 1998 number 88 section 5 schedule 2. Omit 1997 number 3 section 120 schedule 1. Time for proceeding in cases of treason or concealment of treason. 2 witnesses necessary. Section 40. Omit 1997 number 3 section 120 schedule 1. Inciting to mutiny. Section 41. Amend 1986 number 1 section 6. Amend 1988 number 88 section 5 schedule 2. Omit 1997 number 3 section 120 schedule 1. Assisting escape of prisoners of war. Section 42. Amend 1988 number 88 section 5 schedule 2. Omit 1997 number 3 section 120 schedule 1. Overt act section 43. Omit 1997 number 3 section 120 schedule 1. Part 8 procedure chapter 63 evidence presumptions of fact evidence on charge of treason section 633 omitted. 1997 number 3 section 120 schedule 1. Chapter 71 miscellaneous provisions. Names of jury to be given to person charged with treason or concealment of treason. Section 696 omitted. 1997 number 3 section 120 schedule 1. 6. List of legislation for Criminal Code Act 1899. Criminal Code Act 1899 63 Victoria number 9 amending legislation. Criminal Law Amendment Act 1997 number 3. Sections 1, 2, 2, Part 3, Section 120, Schedule 1. This Act is amended. See amending legislation below. Date of assent 3rd of April 1997. Now remember, this is not royal assent. This assent is nothing. Sections 1 and 2 commenced on date of assent. Well, there still has no assent. Remember, we don't have a Governor-General since 1960. They took these criminals, political parties, they took ownership of the Governor-General. Remaining provisions commenced on the 1st of July 1997. 1997 SL number 152, amending legislation. Justice and other legislation, miscellaneous provisions, Act 1997, number 9. Sections 1, 2, 2, and 3, Part 9, Schedule 1, amends 1997, number 3 above. Date of assent, 15th of May, 1997. Remember, this is not royal assent. This is just them taking control, deceiving the people. Commenced on the 1st of July 1997. See Section 2.2. Criminal Law Amendment Act 1997, Act Number 3 of 1997, an Act to amend the criminal law, assented to 3rd of April 1997. They like throwing this assented around, don't they? Schedule 1, Provisions of Criminal Code repealed, Section 120. Chapter 6. Treason and other offences against the sovereign's person and authority. Section 633. Evidence on charge of treason. Section 696. Names of jury to be given to person charged with treason or concealment of treason. The Criminal Code Act of 1899. The Criminal Code, reprinted as in force on the 26th of March 1994, includes amendments up to Act Number 70 of 1993, reprint Number 1, Part 2, Offences against Public Order, Chapter 6, Treason and other offences against the sovereign's person and authority. Treason, 37. Any person who A. kills the sovereign or does her any bodily harm tending to her death or maim or wounding or imprisonment or restraint. B. Kills the eldest son and heir apparent for the time being of the sovereign or the queen consort of the reigning king. C. Forms an intention to do any such act as aforesaid, and manifests such intention by any overt act. D. Conspires with any other person to kill the sovereign or to do her any bodily harm tending to her death or maim or wounding or imprisonment or restraint. E. Levies war against the sovereign. I. Or 1. With intent to depose the sovereign, from the style, honour and royal name of the Imperial Crown of the United Kingdom of Great Britain and Ireland, or any other of Her Majesty's dominions. 2. In order by force or constraint, to compel the sovereign to change her measures or counsels, or in order to put any force or constraint upon, or in order to intimidate or overawe any House of Parliament of any of Her Majesty's dominions. F. Conspires with any other person to levy war against the sovereign with any such intent or purpose at last aforesaid. G. Instigates any foreigner to make an armed invasion of any part of Her Majesty's dominions. H. Assists by any means whatever any public enemy at war with the sovereign. 1. Violates, whether with her consent or not, a queen consort or the wife of the eldest son and heir apparent for the time being of the sovereign, is guilty of a crime which is called treason, and is liable to imprisonment for life, which cannot be mitigated or varied under this code or any other law, or is liable to an indefinite sentence under Part 10 of the Penalties and Sentences Act 1992. Now that sentence there just tells you straight out that they are not allowed to change it. They've got no authority. Concealment of treason, 38. Any person who A. becomes an accessory after the fact to treason, B. knowing that any person intends to commit treason, does not give information thereof with all reasonable dispatch to a justice, or use other reasonable endeavours to prevent the commission of the crime, is guilty of a crime, and is liable to imprisonment for life. Treasonable crimes, 39. 1. Any person who forms an intention to effect any of the following purposes, that is to say, A. To depose the sovereign, from the style, honour and royal name of the Imperial Crown of the United Kingdom of Great Britain and Ireland, or of any other of Her Majesty's dominions. B. To levy war against the sovereign within any part of her dominions, in order by force or constraint to compel the sovereign to change her measures or counsels, or in order to put any force or constraint upon, or in order to intimidate or overawe any House of Parliament of any of Her Majesty's dominions. C. To instigate any foreigner to make an armed invasion of any of Her Majesty's dominions, and manifest such intention by any overt act, is guilty of a crime, and is liable to imprisonment for life. 2. A. just 2. A person charged with any of the crimes defined in this section is not entitled to be acquitted on the ground that any act proved to have been committed by the person constitutes the crime of treason. But a person who has been tried and convicted or acquitted on a charge of any such crime cannot be afterwards prosecuted for treason in respect of the same facts. Time for proceeding in cases of treason or concealment of treason. 2 witnesses necessary. 40. 1. A person cannot be tried for treason or for any of the crimes defined in sections 38 and 39 unless the indictment is presented within 2 years after the crime is committed. 2. Nor can a person charged with treason or with any such crimes be convicted except on the person's own plea of guilty, or on the evidence in open court of 2 witnesses at the least to 1 overt act of the kind of treason alleged, or the evidence of 1 witness to 1 overt act and 1 other witness to another overt act of the same kind of treason. 3. This section does not apply to cases in which the overt act of treason alleged is the killing of the sovereign, or a direct attempt to endanger the life or injure the person of the sovereign. Inciting to mutiny. 41. 1. Any person who advisedly attempts to effect any of the following purposes, that is to say, A. To seduce any person serving in Her Majesty's forces by sea or land from the person's duty and allegiance to Her Majesty. B. To incite any such person to commit an act of mutiny, or any traitorous or mutinous act. C. To incite any such persons to make or endeavour to make a mutinous assembly, is guilty of a crime, and is liable to imprisonment for life. 2. A person who has been tried and convicted or acquitted on a charge of any of the crimes defined in this section cannot be afterwards prosecuted for any other crime defined in this chapter in respect of the same facts. Assisting escape of prisoners of war. 42. Any person who A. Knowingly and advisedly aids an alien enemy of Her Majesty being a prisoner of war in Queensland, whether such prisoner is confined in a prison or elsewhere, or is suffered to be at large on parole to escape from prison or place of confinement, or, if the prisoner is at large on parole, to escape from Queensland. B. Being a person who owes allegiance to Her Majesty after any such prisoner has escaped by sea from any part of Her Majesty's dominions, knowingly and advisingly upon the high seas within the territorial waters of Queensland, aids the prisoner in his or her escape to or towards any other dominion or place, is guilty of a crime and is liable to imprisonment for life. Overt act. 43. In the case of any of the offences defined in this chapter, when the manifestation by an overt act of an intention to effect any purpose is an element of the offence, every act of conspiring with any person to effect that purpose, and every act done in furtherance of the purpose by any of the persons conspiring, is deemed to be an overt act manifesting the intention. Chapter 63. Evidence. Presumptions of fact. Evidence on charge of treason. 633. On the trial of a person charged with treason, evidence cannot be admitted of any overt act not alleged in the indictment. Chapter 71. Miscellaneous provisions. Names of jury to be given to person charged with treason or concealment of treason. 696. When a person is to be tried for the crime of treason, or of becoming an accessory after the fact to treason, or of failing, when the person knows that any person intends to commit treason, to give information thereof with all reasonable dispatch to a justice, or use other reasonable endeavours to prevent the commission of the crime. A list of the jurors with their Christian names and surnames written at full length and with the true place of abode and description of every juror is required to be given to the person in the presence of 2 credible witnesses 10 days before the person is called upon to plead to the indictment.
There's no royal assent on any local government act in Australia, ever. We voted 3 times to have no councils, no local government.
We haven't got local government.
I wish to further discuss the corruption that continues in Queensland local government.
We haven't got local government.
The councils and the Local Government Association of Queensland.
We haven't got local government.
At the heart of this local government corruption has been the Local Government Association of Queensland, the LGAQ, a private company that has a special relationship with the Queensland government.
We haven't got local government.
I address the Senate tonight about corruption in local government in Queensland.
We haven't got local government.
And I am a strong supporter of local government.
We haven't got local government.
Corruption does not constitute good governance. Being in jail does not constitute good governance.